Just thought I'd come online and mention a few things about the work health and safety bill that was passed through the upper house late last week. Um, Principally because we've had some people inquire through our networks as to what those laws are, what the changes are to the safety laws in WA, and how those laws, the new laws, may actually impact upon them. So we've been involved in a number of seminars over the last couple of months dealing with the prospect of these new laws, and now that they're, well, almost due to commence, subject to the drafting of regulations, it's important, I think, that employers particularly need to understand or get an understanding of how those laws may impact upon them. So the task today is really just to identify a couple of those key questions that have been posed about the changes, and to hopefully give some guidance to employers as to what they might look to do once the new laws become operative. Um, so, prime question, of course, is what are the changes? The changes are, in some respects, quite significant. The primary change which the government and the media have focused on is the introduction of what they call the crime of industrial manslaughter. In some respects, this is a little bit of a misnomer because WA has had what we'll say industrial manslaughter laws in place for some time. That is, that we've had the prospect of a penalty of imprisonment being imposed where a worker has died on the site, on a workplace, or in a workplace, sorry, in circumstances which constitute gross negligence. Um, so, what these new laws do is effectively introduce greater penalty regimes in those circumstances. There's a slight change too to the terminology used. The concept of gross negligence has really been replaced by the concept of crime, and there's some tweaking of the terms under the legislation which may see a different approach by the courts to that concept. So that's one fundamental change, and I'll come to deal with the issue of penalties in a minute. Perhaps the primary change, though, lies in the concept of where there's a fatality at the workplace, and that fatality has risen because of a failure by a person in charge of a business unit to adhere to the primary duty or a duty under the Act. So if we look at the situation, the new laws will provide for a situation where a company or organisation or an individual has a health and safety duty whilst undertaking that business. That person fails to comply with the duty, and as a result of that failure, a death of an individual occurs. In that circumstance, so where you simply have a breach of a duty of care which results in the death, that is a new measure under the industrial manslaughter provisions. In those circumstances, a business can be susceptible to a fine, but from a personal perspective, someone in charge of the business unit or an officer of a corporation or a partner in a partnership could also be susceptible to a fine of $3.5 million, and I think it's $3.5 million, and prison term of up to 5 years. Where it becomes a crime is where there's an additional component, and that additional component is that the person in charge of the business has engaged in conduct with knowledge that that conduct is likely to cause death to an individual, and acts in disregard of that likelihood. So almost similar to the concept of gross negligence, but expressed differently. And where you have that additional component which kicks it into the crime of industrial manslaughter, an individual could be subject to penalties of a fine of $5 million or imprisonment up to 20 years. So significantly greater penalties than that currently exist. There's a few other tweaks to the legislation as well. The concept of health now includes psychological health as an express issue to deal with. Other changes in the bill also revolve around insurance. There's a prohibition on a business unit and or an individual from obtaining insurance in relation to a penalty that would be imposed. The current concept of gross negligence or a penalty under the existing Act would be able to be insured through normal insurance mechanisms. However, that position will change with the introduction of this Act. And in context of how that might affect a person or employer, if we look to some examples over east where prosecutions have been undertaken over there, in some cases the penalties have been fines of near to $1 million. There's one case in Queensland where that was certainly an outcome. So if the courts in Western Australia were to take a similar approach, particularly in the context of the lesser offence, which does include a potential jail term as a penalty, and fines of up to $2.5 million, then the person who actually is fined will not be able to turn to their insurer to cover the fine itself, and will have to find that money from within their own means. There's also a few other changes to the legislation. One important one, I think, is to protect what is known as whistleblowers. Those who report safety breaches or safety concerns, and then there is some adverse action taken against them. There are protections in the bill and the new laws to assist those people. So from the point of view of key changes to the legislation, they're probably the main issues that actually arise. So the second question that's posed a lot is, can I be exposed to a penalty of jail time, and when would that occur? I've just sort of covered those prospects, but to go over them once more, jail time as a penalty will now be an issue, if you like, in a prosecution where there has been a breach of an underlying duty, and that breach has resulted in the death of a worker or someone on the work site. I need to be a bit careful here too, because the Act extends beyond worker. The concept of employer and employee have been dissipated, if you like, and the net has been cast wider to really capture all persons that are actually on a work site. So the duties have been extended in that respect as well. So coming back to that question, when would jail time be a prospective penalty? As I said, the first instance would be where there's a breach of duty, which results in a person being killed at the workplace. The second arises where there has been, in the old verbiage, gross negligence by the employer. And that's a situation where the employer knows that there's a prospect of death in the workplace, but chooses to do nothing about dealing with that safety issue and a death arising. The jail time prospect is anywhere from 5 years to 20 years. If we look again at examples from the eastern states where similar laws have been in place for a few years, then persons in charge of a business unit who are subject to a prosecution and actually found guilty will find themselves in a situation where the court will actively look to imposing a jail an imprisonment term. That's a real prospect, given what we know has happened over east. And it's a prospect that sort of underpins the legislation from this government's perspective. The government sees these changes as really trying to put some more pressure and incentivise employers to actually take safety and health issues more seriously than they have perhaps in the past, to limit and not only limit but to eliminate deaths in the workplace. So, what effect do these changes have on those areas that we typically deal with, which is agribusiness and tourism? It's going to be difficult to say because obviously all accidents and incidents in a work environment depend upon the circumstances that are at play at the time. But the primary effect is probably going to be, I can think of perhaps a few things. First, hopefully a greater awareness of the need to actually deal with safety hazards and to assess your duties and actually take steps where reasonably practical to do so to minimise those hazards. Secondly, this issue about an ability to pay the penalty, where significant penalties may be imposed, and those penalties could be, could range from $2,000 up to $2 million. It's difficult to see or to hypothesise what the courts may do over here, but one suspects that the range of penalties that will be applied on a breach of duty that results in a death is probably going to be in the hundreds of thousands of dollars. So businesses will need to factor those issues in, and that particular cost burden will hopefully incentivise employers to look at their safety issues. So that's going to be a significant impact, both within tourism and agribusiness. And when I talk about agribusiness in this sense, I'm talking about typically farm businesses. They're quite unique businesses in many senses, but more particularly because often accommodation is provided not necessarily as part of the employment regime, but as a benefit to the employee. Additionally to that, within those sectors, often the employer will have a residence themselves. The employer will actually reside on the land that they're using for farming purposes. So whilst you've got say, a zoning of rural land, you've nonetheless got a residence that the employer and the employer's family occupies. And again, in both those sectors, you have an additional issue which is perhaps unique. You often have children in that environment. And as a very generic statement, children should never be in a workplace. But in tourism and agribusinesses sense, you'll invariably find children within a workplace because it's where they live. That can create some significant problems, and one would hazard a guess under the workplace laws that will come into play, where there's death of a child on a farm, that might be an issue that comes up by way of a prosecution, because the employer's responsibility, or the person in charge of the business unit, their responsibility is all encompassing. It's just not to employees, it's to anyone on that site. So there's going to be some interesting quirks that these new laws give rise to, which I'm not sure that the regulators, our parliamentarians, have actually given thought to those sort of unknown ramifications that might flow from the introduction of the new concepts of business unit versus employer and employee. So one of the other important questions that has arisen is what happens in relation to a prosecution. If there has been a death of a person at the worksite, well, what then happens? In a very generic sense, obviously WorkSafe as the regulator is going to investigate. There'll be obligations on people in charge of the workplace to provide information to the WorkSafe investigators. Those people are not protected by a right to silence. They're bound to answer questions posed by the regulator, and if they fail to answer those questions, they can actually be prosecuted for that failure. So that's an issue, certainly. The protection, if you like, for that person, though, is that whatever information they do give to the regulator through that investigation process, that information cannot be used against them if there is a prosecution. However, that information can be used by WorkSafe to source other information which can then be used in a prosecution. So this right to silence issue, I think, whilst the existing laws also encompass the same mechanisms, I think there's perhaps a loophole in this situation where the issue flips now into a crime to be prosecuted more in the context of a crime than historically it has been. So if there has been a death at the workplace, or even a serious accident which has caused serious injury or harm, persons in charge of that worksite really should seek advice and assistance urgently, immediately, I would say, to help them through that process and through the potential prosecution that may follow. There will be obviously relevant defences that can be raised if there is a prosecution. The primary defence under the Act will be where there's a breach of duty only, where the person has taken reasonable measures to eliminate and or reduce the hazard to the people concerned. And in very brief terms, that test comes down to reasonable steps. Have you taken reasonable steps? And in the circumstances, have you the resources to be able to take relevant steps? So typically in a tourism and agribusiness sector, businesses can be cash poor, in that particularly for agribusiness, farming, where income may be generated in maybe one or two instances per annum. It's often not a month by month situation where income's coming in. In those circumstances, you really need to be budgeting for the provision of safety costs, if you like. And that would be something that businesses will need to factor in, I think, for the future as an item within their budget and normal expenditure to deal with safety concerns and dealing with hazards. So in the context of a prosecution, whilst you may not be able to insure, or you won't be able to insure against a penalty, insurance can still have a role here in the sense of covering legal costs and other costs that might arise through that process. So it really just will become a question of whether insurers will actually provide a product which only covers the legal costs of actually engaging in a prosecution. And we'll just have to wait and see what happens there. But if costs are not covered by insurance, it wouldn't be unheard of really to be spending again tens of thousands of dollars on legal representation in a prosecution. And these are factors that businesses need to really take account of and be aware of, not just because of the new laws coming into play, but currently some businesses no doubt would not be insured against this type of issue. And they need to be conscious of the potential costs involved. So obviously the key question most people turn to is, what should we do? New laws are being introduced which create a crime where there's a death on a site in circumstances where the person in charge of the business unit knew that there was a hazard which might cause a death and did nothing about that. Similarly, where there's a breach of duty that results in a death, there's also the potential for fines and jail time. Those fines won't be insured. Should we be doing anything different to we're doing now? I think the answer to that is probably yes. I think the key message the government is trying to, one key message the government is trying to get into the community with these laws is to treat safety and health issues in the workplace much more seriously than they have in the past. So if you want to avoid the potential of having to dip into your pocket not only for legal fees but to pay a couple of $100,000 penalty, and if you want to avoid a jail sentence being imposed, then these laws will incentivize you, hopefully, to actually start thinking perhaps more seriously than you have been in the past. Now, I say that in a very generic context because clearly there are businesses that do take safety and health issues very seriously. We look at perhaps the construction and mining industries, which may well be the target of these laws, but for very many years now, those industries have dealt with safety and health in what I would call quite serious and significant steps. We've worked for some people that have been exposed to disciplinary action because of failure to adhere to safety guidelines and rules within a workplace. And sometimes those disciplinary actions may seem harsh, particularly where they result in a dismissal of the employment. But they're steps that are open to employers, and we can't deny an employer the right to take those steps where someone has perhaps not taken the necessary steps and abided by the rules that have been imposed by the employer. As I said earlier, another thing that businesses within agriculture and tourism could perhaps look to do is, if they're not currently, is to budget for or create a budget line at least for the taking and assessing of hazards and improving safety regime within their workplace. This is not a difficult thing to do. The most difficult thing to do really is the implementation stage. Things like inducting new employees, maintaining a register of training for new employees, and training where you have new equipment, and to maintain logbooks, particularly for where machinery is serviced and or repaired. Make sure that there is a regime for the service of machinery. Some machinery is not used day in and day out and might only be used across 2 or 3 months a year, but it's important that there is a maintenance log, if you like, kept in relation to that type of machinery. So there's an abundance of things that employers and people in charge of business units probably ought to be doing if they're not currently doing those things. That list is not an exclusive list, and it will depend on the nature of the business being undertaken as to what methods, what reasonable steps can be implemented to protect workers and others from injury and death in the workplace. So they're the prime issues really that we've been faced with. Questions, I should say, that clients have raised. And I might leave you with perhaps an issue which may seem quite innocuous, but it provides perhaps a good example of how easy it may be to fall into a trap of being prosecuted. We've had a circumstance where we've provided advice to a client on a hypothetical circumstance. Now, this circumstance arises in an office environment, but we can equate this quite easily to an agribusiness and tourism environment because invariably within the farmhouse or within the hotel or motel that you might be residing in as part of your business, you will have an office location. In that office location, you'll have computers, typically printers, you'll have electric cables and computer cables, most often just lying around on the floor. And in those circumstances, firstly, they can pose a trip hazard, and secondly, they can pose a hazard through electrocution. Now, that might be a bit far-fetched, and in some circumstances that probably is far-fetched, but in a circumstance where you know those cables are there, you choose to leave them lying around the floor without actually tucking them away somewhere out of the way, so they're at least not a trip hazard. if they become a trip hazard, someone is electrocuted because of that hazard, then you can see, I think, that in those circumstances, because there's such an easy way to eliminate the hazard by just bunching them together and putting them against a wall or hiding them so they don't cause at least a trip hazard. But if someone does trip, is electrocuted, there lies, I think, a prosecution for breach of duty resulting in death, where the penalty will be a fine and a potential imprisonment term. Now, that's a pretty quaint hypothetical, but to me it demonstrates the simplicity, if you like, of how an accident may occur which results in death, which would be avoidable. But how also in those circumstances a person who's prosecuted would be susceptible to an imprisonment term. So I think I'll leave you with that, and if you have concerns or issues or seek advice in relation to the new laws, or even your existing laws and obligations under the existing Occupational Safety and Health Act, either call myself or my team here at Bailiwick Legal. These new laws will, when they actually come into play, which the government says will be around mid-year next year, they will bring a new level of complexity to the safety regime within WA, which may take a few years and court cases to work through. We're here to help if we can, so if you're in that situation, please give us a call. Thank you for your time.